The wall of permits collapses. For a century, the Sullivan Act model was the gold standard for gun control. The logic was simple and insidious. The state acknowledges your right to exist, but reserves the right to decide how you exist in public. They turned a right into a privilege, and then they turned that privilege into a revenue stream. Bureaucrats became the gatekeepers of freedom, forcing citizens to prove their worthiness or good moral character before exercising a right that was supposed to be inalienable. That era ended at 10 a.m. this morning. The Supreme Court's ruling is explicit. They didn't just strike down may issue or specific restrictions. They attacked the core premise of licensure itself. The majority opinion declares that the Second Amendment protects a right that belongs to the people, not the permitted. The court ruled that any system requiring a law-abiding citizen to beg the government for permission to carry a firearm for self-defense is a violation of the 14th Amendment. The legal standard is devastatingly simple. The court applied the Bruen test, text, history, and tradition, and found that there is no historical analog for charging a fee to exercise a fundamental right. You don't pay a tax to speak your mind. You don't apply for a permit to plead the Fifth. And now, the court has ruled you cannot be forced to pay a fee or wait for a background check to bear arms if you are a law-abiding citizen. This is the constitutional carry standard applied federally. The ruling states that the right to carry does not start when a sheriff signs a piece of paper. It starts when you are born. Requirements that impose financial hurdles, waiting periods, or subjective suitability judgments are now presumptively unconstitutional. The wall that separated the government's power from your individual freedom has been rebuilt, and this time it is reinforced with steel. The DOJ's unexpected betrayal. Here is the twist that the mainstream media is trying to bury. For decades, the Department of Justice has been the spearhead of restriction. They have fought every expansion of gun rights from Heller to Bruen. But in this case, silence. Actually, it was worse than silence. It was complicity. Internal memos that we've analyzed show a Department of Justice that read the writing on the wall. Federal attorneys, the same ones who usually argue for public safety interests, advised against defending the state permit systems. Why? Because they knew the legal foundation was rotten. Post-Bruen, the DOJ realized that defending arbitrary permit fees and processing delays was a losing battle that could result in even broader restrictions on federal power if they pushed too hard. So, they stepped aside. The DOJ declined to challenge the core of the plaintiff's argument. In their briefing, they effectively conceded that if a right is fundamental, it cannot be licensed. This is a seismic shift in the tectonic plates of federal enforcement. At least 15 states noticed this weakness and joined the briefs supporting the shift toward permitless carry. The federal government has essentially admitted that the system of licensure was a house of cards. They chose to let it fall rather than risk a ruling that might strip them of other regulatory powers. This isn't benevolence, it's damage control. They cut the permit system loose to save the rest of the administrative state. But the result is the same. The federal enforcement arm just walked off the battlefield. Constitutional carry goes national. Before this morning, constitutional carry was a regional phenomenon. It was the law of the land in Texas, Florida, New Hampshire, and 20-some other states. It was a patchwork quilt of freedom. If you crossed a state line, you went from a citizen to a felon in 10 feet. That map has been burned. The court has nationalized the standard. The ruling establishes that the Constitution provides the floor, and that floor is permitless carry. States that impose good cause requirements, character references, or mandatory training fees are now exposed to immediate injunctive relief. This effectively forces every state into the constitutional carry column. The logic is inescapable. If the Second Amendment applies to the states through the 14th Amendment, and if the Second Amendment forbids licensure fees, then no state can mandate a permit. Judges in lower courts, even the ones in the Ninth Circuit who hate this, are now bound by a single rule. They can no longer apply intermediate scrutiny or balance your rights against the state's interest in feeling safe. They must look at the text. Does the text say, "shall not be infringed unless you pay $150"? No, this doesn't create a new right. It excavates the original one. The right recognized by the founders, affirmed by Heller, expanded by Bruen, is now enforced by the Supreme Court as a negative liberty. The government simply cannot require a slip of paper for you to carry a tool of self-defense. The blue states scramble. If you want to see panic, Look at the state capitals in Sacramento, Albany, and Springfield right now. The reaction from the anti-gun strongholds was immediate and visceral. Their entire regulatory frameworks just evaporated. New York, California, New Jersey, Maryland, Hawaii, these states built their public safety models on the idea that they could bottleneck gun ownership through bureaucracy. They couldn't ban guns outright, so they banned the process of carrying them by making it expensive, slow, and humiliating. That justification is gone. California's May issue remnant is dead. New York's Concealed Carry Improvement Act, which was their desperate attempt to evade Bruen, cannot survive this precedent. Illinois is facing a tidal wave of lawsuits challenging the FOID card system itself. If you cannot require a permit to carry, you certainly cannot require a card to possess. Gun rights organizations, FPC, GOA, SAF, have already filed motions for preliminary injunctions in dozens of jurisdictions. They aren't waiting for the ink to dry. They are demanding immediate suspension of enforcement. Sheriffs and state attorneys general in these blue states are facing a brutal choice: enforce the old laws and face personal liability for civil rights violations under Section 1983, or comply with the Supreme Court and watch their control grid dissolve. For the gun owner living behind enemy lines, the tide has finally turned. The shackles are off. The permit industry crash. We need to talk about the money, because behind every tyranny, there is a ledger. The permit system wasn't just about control, it was a billion-dollar industry. And that industry is collapsing in real time. Think about the revenue streams: application fees, renewal fees, fingerprinting processing fees, mandated training course fees, psychiatric evaluation fees. In states like New York and California, a carry permit could cost upwards of $1,000 when you factor in all the mandates. That money fed the state bureaucracy. It funded the very departments that were designed to disarm you. That cash flow just hit zero. Permit application and renewal fees are legally toxic now. If you charge a fee for a right, you are violating the ruling. Several states have already suspended their payment portals to avoid class action lawsuits demanding refunds. But it goes deeper. The compliance industrial complex is freaking out. Training companies that depended on government-mandated contracts are reporting mass cancellations. State-run databases that tracked licensed carriers, lists that were often leaked or abused, are losing their legal foundation. If there is no permit, there is no list. This is a financial singularity for the gun control state. The system was built on the premise that they could tax you for your rights. That tax has been repealed. Locking in freedom. While the blue states panic, the free states are moving with blinding speed. Governors in the Free America bloc are not just celebrating, they are fortifying. In Florida, the governor has already issued an executive order directing the Department of Agriculture to cease all permit processing mandates and transition the department to a voluntary verification system only. He called it a restoration of the natural order. Texas and Montana passed emergency triggers that automatically repeal remaining location restrictions now that the permit distinction is gone. Tennessee's Attorney General issued statewide guidance declaring that local ordinances restricting carry to permit holders only are void because the category of permit holder is now legally indistinguishable from citizen. South Carolina and Alabama are drafting state constitutional amendments to codify this ruling. They want to ensure that even if the Supreme Court shifts in 20 years, the state constitution will remain a fortress of permitless liberty. This is coordinated. This is strategic. They are salting the earth so that the permit regime can never grow back. The law enforcement crisis. Behind the headlines, there is chaos on the radio waves. Law enforcement officers are navigating a world where the rulebook has been shredded. For 50 years, the standard police procedure for a man with a gun call was, "Do you have a permit?" If the answer was no, the handcuffs went on. Now, that question is constitutionally irrelevant. Police departments are issuing frantic memos. Do not detain for mere possession. Do not demand licensure without probable cause of a crime. But old habits die hard. In counties across Georgia, Idaho, and Arizona, constitutionalist sheriffs are publicly celebrating, declaring that their deputies will no longer act as tax collectors for the state. But in hostile jurisdictions, the friction is dangerous. You have officers who have been trained that gun equals criminal facing a legal reality where gun equals citizen. Police unions are demanding emergency indemnification from legislatures because they know that one bad arrest, one violation of this new ruling, will result in a massive civil rights lawsuit. We are witnessing a paradigm shift in policing. Law enforcement must return to investigating behavior, not status. They can no longer use the mere presence of a firearm as a pretext for an investigation. This is the restoration of the Fourth Amendment alongside the Second. The empire strikes back. Do not make the mistake of thinking the gun control lobby will go quietly into the night. They are wounded, but they are dangerous. Within hours of the decision, Everytown, Giffords, and the Brady campaign mobilized. They are terrified. They called the decision a death sentence for public safety. But watch their actions, not their words. They are pivoting to a new strategy. Geography as a ban. If they cannot demand a permit, they will try to ban the location. Expect to see a flood of bills in blue states declaring entire cities, transit systems, and public parks as sensitive places. They are trying to recreate the permit ban by making it impossible to walk 10 feet without entering a felony zone. They are also pushing for mandatory insurance schemes. If they can't license the person, they will try to license the liability. They are drafting laws that would require million-dollar insurance policies to carry, a financial permit by another name. But they are fighting uphill. The Supreme Court's ruling anticipates this. The Bruen history test applies to sensitive places too. There is no history of banning guns in entire cities. There is no history of mandatory insurance in 1791. They are throwing spaghetti at the wall, but the wall is made of Teflon. The historical chain. This moment didn't happen in a vacuum. This is the third strike in a combo that started in 2008. First, Heller, 2008, told the government, "You cannot ban the gun." It established the individual right. Second, McDonald, 2010, told the states, "This applies to you too." It incorporated the right. Third, Bruen, 2022, told the courts, "Stop making up excuses." It established the history and tradition test. And now, this ruling tells the bureaucracy, "You cannot govern the right." It is the logical conclusion of the constitutionalist legal movement. The court has finally aligned the Second Amendment with the First. You don't need a license to pray. You don't need a license to write an op-ed. You don't need a license to carry. The Bruen test is now the supreme law of the land, reinforced by this decision. Text, history, tradition. Nothing else matters. No interest balancing. No public safety studies funded by Bloomberg. If the founders didn't do it, you can't do it. The next battlefield. So, what do you do now? The permit is dead, but the war isn't over. The next phase is implementation. The Supreme Court has spoken, but the governor of New York is hard of hearing. We are going to see a period of massive civil disobedience and legal friction. You will see federal lawsuits challenging these sensitive place maps. You will see challenges to the ghost gun restrictions using this same logic. You will see a push to repeal the NFA restrictions on suppressors and SBRs, arguing that if you don't need a permit for a pistol, you shouldn't need a tax stamp for a muffler. But here is your immediate marching order. Stay dangerous, but stay smart. Just because you can carry without a permit doesn't mean you shouldn't train. The legal responsibility for every round you fire is still yours. Watch your state law. The Supreme Court ruled, but state statutes don't disappear by magic. They have to be repealed or struck down. Until your state officially updates its code, you are in a legal gray zone. Do not be the test case unless you have a lawyer on speed dial. Keep your eyes on the horizon. The anti-gunners are pivoting to banking, insurance, and social credit scores. They will try to debank gun owners. They will try to cancel your insurance. The fight is moving from the courtroom to the boardroom. A new era has begun. The paperwork is burning. The gatekeepers are unemployed. Freedom is reclaiming its seat at the table. But freedom is not free. It requires maintenance.